Morning, everybody, and thank you for joining. Welcome to Retinue's Contingent Labour webinar series. I'm Rachel McKenzie, and I'll be the host for today's session. Today, as you know, we're talking about the Employment Rights Bill. So this is one of Labour's flagship workplace reforms and a cornerstone of their plan to make work pay. So the bill was introduced to Parliament in October 2024, and at its core, it focuses on regulating employment practices such as zero-hour contracts and fire and rehire reforms. It also introduces a broad set of day one rights, including protection from unfair dismissal, paternity, parental and bereavement leave, flexible working by default and statutory sick pay from the first day of absence. Some of the other key reforms that we're going to talk about today include guaranteed hour contracts, so requiring employers to offer stable hours to certain workers, mandatory notice for shift changes, new protections for pregnant employees and new parents, and stronger safeguards against harassment. All of these changes are going to be phased in, and some of the consultations are already underway, as many of you know. Some of the provisions are expected now to take effect from 2025 and rolling into 2026, so they will be phased, which is helpful for most people, I think, on this call. But overall, I think it's fair to say that for both employers and employees, this is the most substantial transformation of UK employment law in a generation. I've worked in the industry for about 20 years and supported organisations through a whole range of different workforce changes. So thinking AWR and IR35, introduction of national living wage, but nothing that I've seen has been as wide-ranging as what we're now facing with the Employment Rights Bill. 15 years ago, I co-founded Retinue. Everything we do is rooted in frontline workforces, so really fast-paced and high compliance environments. Lots of the organisations that we work with day to day rely heavily on their flexible workers, and that ranges from managing seasonal peaks to delivering regional projects, flexing their workforce to meet different client service levels. And all of our customers at the moment are talking about how they strengthen and deepen their workforce data and visibility. We already do things like workforce tenure tracking, but really, how does that play into updating policies? How do we adapt systems and processes and put really robust governance processes in place to manage the new compliance requirements and the new risk that's going to come alongside this legislation? At Retinue, we've always taken a really pragmatic and hands-on approach to legislative and regulatory changes. So please be assured we are here to help you understand cost, risk, and the opportunity that any change brings. And between the team that we've got here today, hopefully we can help you shape some practical and really tangible solutions. So on that note, I'm really excited to have two fantastic guest speakers with me today. They're going to walk us through some of the key changes coming down the track as part of this new bill, and crucially, how those proposals are likely to impact your use of contingent and temporary staffing. Both Alison and Nikki bring lots of legal expertise and extensive advisory experience, and both have supported organisations through these major shifts in employment law in past years. And that perspective is really critical when you've got organisations like the ones that we've kind of got on the webinar today that just can't stop and stand still while we implement change. Everybody's running at 1,000,000 miles an hour. So hopefully today and going forward, we'll be able to collectively support you if you are looking at these changes and, like me, thinking, what on earth do we do with some of this? Earlier this year, we also saw a shift in workforce cost driven by ENIC changes. We've lived and breathed that for the last 6 months, alongside HMRC's tougher stance on tax avoidance schemes. And the government have just done a recent announcement on umbrella risk, as you know. So at the request of a couple of attendees today, we are going to touch on both of those things. We're not going to do a deep dive into them, and we'll pick those up separately in other webinars. But on that note, Nikki, could I ask you to introduce yourself?
Thank you. Yeah, hi, I'm Nikki Green. I'm a partner in the Employment and Pensions division of Capsticks. I head up the independent sector within the employment team. We advise private healthcare providers, charities. I'm basically responsible for the independent sector, and I'm here today to talk to you about what I think are the most significant changes for you, we're going to really focus on guaranteed working hours because that's a huge change, and protection from dismissal, so the day one rights. But I'm also going to touch upon some topics which I think are really impacting how employers work at the moment. That final topic, sexual and third-party harassment, sexual safety in the workplace, is a really hot topic for me. So I'm going to give you hopefully some helpful tips on how you can deal with that and improve the situation that you may be facing within your workforce as you move through and start to get to grips with some of these changes. As Rachel said, the changes are a huge scale. We've never seen it before. So it's not a small task, but hopefully we can help today.
Thanks, Nikki. And over to you, Ali.
Yeah, thank you, Rachel, and thanks for inviting me on. As you know, when I grow up, I want to be a law lecturer, so any opportunity to start talking about the law to an audience is welcome. I'm the Group General Counsel for nGAGE Talent, which is the parent company for Retinue, but we also have over 20 recruitment businesses in the UK and across the world. My team provide legal services in contingent workforce in a number of locations. And so today I'll be talking about how we as a recruitment business and as a managed service provider neutral vendor are looking to the regulations as well.
Thanks, Ali. So a couple of housekeeping points before we start. The agenda for today is in the chat. So we're going to cover guaranteed working hours. We're going to talk a little bit about protection from dismissal. We're going to talk about the fire and rehire reforms, and then we're going to go on to statutory sick pay from day one. And at the end of the session, we're going to try and cover umbrella company regulation and the sexual and third-party harassment point that Nikki's just touched on. So the webinar is being recorded. You'll be able to access a copy on demand afterwards. So we'll share the details via email after the event. And we will make time for Q&A at the end. A few questions have already come in, so we'll try and cover those during the event. And if you'd like to add yours during the event, please just use the Q&A tool or the chat function to the side of the screen. We typically do get more questions than we can cover. So if we don't answer yours today, we'll share contact details at the end and we'll loop back to you. You'll also see polling questions pop up during the webinar. I think we've got 3 today. So please do contribute your point of view as we go through the webinar. And all attendees are muted, so you won't be able to unmute and jump in to ask questions. So please do use that chat function. I think of it as the reverse of Teams, where we're all trying to speak but forget to unmute. So yeah, please do contribute your thoughts and questions as we go. Finally, we've got a 1-hour session today with loads of great content. So let's get started and try and crack through as much as possible. We're going to start the session with a quick poll. So Terence, could you just pop the poll up on the screen, please? So like so many of these things across organisations, these changes are going to be cross-functional as an impact across businesses. So who, if anyone, within your organisation is leading on understanding the impact of the changes and the implementation programme as of today? Great, and I think you should be able to see in the poll option at the bottom right-hand side of your screen the response from other participants. Yeah, really interesting.
That's right, and currently it's looking at so 15 for HR, so 60% HR, 20% other, 12% procurement team, 4% finance, and 4% legal team.
Fantastic. So it looks like there isn't a clear single starting point across everybody, and that actually is typically what we find with these large complex projects, that individuals within the organisation will start to understand parts of the impact, whether it's cost, whether it's the supply chain risk, and whether it's the impact of employees. But certainly we'd expect to see workforce significantly engaged in leading on this. Okay, so let's start with one of the most significant changes in the ERB, and one that lots of organisations are already sensibly trying to prepare for. So guaranteed hours. So this part of the bill goes right to the heart of how flexible work is managed in the UK. And for employers, it's going to represent a real shift in workforce planning, compliance, resourcing models. And for workers, it's raising questions already about flexibility and choice. I think it's going to be one of the first major tests of how the reforms will play out in practice. And we're working with organisations already on how we think this can be effectively operationalised without too much organisational disruption. Nikki, can I hand over to you to talk us through this part of the bill?
Sure. And I think the point to make at the beginning is we talk about contingent workforce, don't we? And that can include agency staff, but also for lots of organisations, it can include your bank staff. Lots of organisations have banks. So it's not just agency staff, it's quite broad, the contingent workforce. But what we're focused on now for this part of the talk is about the guaranteed working hours, which are proposed for 0 hours workers. And we do focus on that, but also low hour workers. I've been kind of talking to lots of different groups, and one suggestion that was made was, well, it might be better for us from an administrative point of view to just offer low hours, fixed contracts. But the fact is, we don't know what low hours means. We don't know what the government is going to put it within the bill and the regulations which will follow. We're missing so much detail here. Makes it pretty hard to plan. There was some talk about 16 hours being the low hours threshold, but the fact is we don't actually know at the moment. So we're talking about 0 hours workers and low hour workers. And the reason the government has brought it in is to avoid exploitation, essentially. It's a really good thing. But I think we all recognise that we're probably using workforces where individuals, sorry, Reese has just said, can I check if the sound is working? Hopefully the sound is working for everyone, but maybe someone from IT can just check on that. I'll keep going because I think people can hear me.
Yep, we can hear you fine. We can hear you fine.
Okay, Fab. It's just to say that it's been put in to avoid exploitation, but you will know that you have workforces which really enjoy flexible working and don't want guaranteed hours and don't want permanent contracts, because the point of this section of the ERB is that you will be obliged as employers to provide permanent contracts to your low hours and 0 hours workers. And lots of workers don't want to work in that way. You might remember that the previous government was talking about offering a right to request a permanent contract for people on 0 hours. And the current government have taken that further and said, no, the obligation sits on the employer to make the offer. And that obviously makes it very tricky for employers. A point I want to make about timing with all of this, and Rachel said that it's going to be staged. It absolutely is. And there are some changes that will happen immediately. They tend to be the trade union changes, which I don't think most attendees will be necessarily that concerned with here, because I don't think you have unionised workforces. So those are the 2025 changes, 2026 changes. The guaranteed hours changes are looking to take place in 2027. So you've got a while. I think what I want to make clear with this talk is that we're not expecting everything to happen overnight. There will be stages. So you've got time to plan, which is great, but planning is key. So we've got a situation where we want to be offering, the government wants to be offering guaranteed hours, employers to be offering guaranteed hours. We're at a stage where the House of Commons bill has passed to the House of Lords, and the House of Lords introduced an amendment very recently to say that they want it to go back to being a right to request. So the opposite of what the government wanted. The bill now goes back to the House of Commons, and they have to make a decision about whether they accept the House of Lords amendments. Basically, we are in a stage called ping pong, where bills bounce between the House of Lords and the House of Commons. So in terms of the timings that you will see published, it again is up in the air. This could all take a lot longer than the government intends it to. So as the bill stands at the moment, it's been amended by the House of Lords to say it should be a right to request. I very much doubt the House of Commons has agreed to that. The Labour government, when it came in, was absolutely certain it wanted to be the obligation on the employer. That's where it's going to sit. There was a section within the ERB which talked about the ability to extend it to agency workers. There was a consultation that took place in 2024, and it was agreed that the rights to guaranteed hours contracts should apply to agency workers. They wanted to avoid a loophole, basically, with employers using agencies too much to avoid guaranteed hours. The obligation to offer the guaranteed hours sits with the employer, but you will naturally have discussions with agencies about how that works in general, because there are some very key parts to the guaranteed hours provisions within the ERB about notice of shifts, cancellation of shifts, and payments which can be made if there is a late cancellation to shifts. So I very much expect there to be a focus on your relationship, employers' relationships with agencies moving forward, because agency workers are included. Essentially, the guaranteed hours and the low hours, the guaranteed hours contract is based on a reference period. Again, the ERB doesn't specify exactly what the reference period is going to be. We think it's going to be 12 weeks. So there will be a situation where you have to look back and make an offer every 12 weeks of a permanent contract to a 0 or low hours worker. And that's a huge administrative, I can't get my words out, task. And I don't underestimate that at all. So understandably, employers are concerned about the guaranteed working hours and whether there is any exception that can be made to it. There are a couple of exceptions within the ERB, and one of them is about a limited contract that can be offered where there is a specific task that the worker is undertaking. So that's something you might like to explore. The second one, and Alison, I don't know if you want to come in on this bit, is about collective agreements. Collective agreements are agreements in the UK under the legislation that we have between unions and employers, or unions and employer associations. And I work a lot with the public sector, and they are heavily unionised, and collective agreements are very common. There is an exception within the ERB to say that there can be a collective agreement where you essentially disregard the guaranteed working hours section of the ERB, provided it forms part of the contract of employment of the worker. So that's great. That's a get out for those organisations which recognise unions. If you don't, that's not necessarily going to be an exception which you can utilise. But I will pass over to Ali at that point, actually, because I think you had some points to make, didn't you, about what happens in Europe with employer associations?
Yeah, absolutely. I think just before I go on to that, I think, Nikki, you make a really good point that we are still waiting for secondary legislation, and we're still waiting for that ping pong phase of the bill to go through. Typically, it would have completed by now, but we're talking about those changes we know are coming through, but that sort of secondary legislation will really feed into exactly how it looks. So in relation to the collective labour agreement, I don't know if you'd agree, Nikki, but I think this is probably one of the closest moves in employment legislation to European style law that we've seen. And in Europe, quite often the recruitment businesses will be part of a collective labour agreement through their employer association. Now, we don't know if that's going to be done in the UK, but it is a possibility. We at nGAGE are members of collective labour agreements in Germany, the Netherlands, and we're currently reviewing whether in France or Spain we become members. So it's something we have a lot of experience in. And in those circumstances, we become a member of the Employment Association, and we have a number of employment associations in the UK. So we become a member of that collective labour agreement and set the terms which the agency workers will be a part of, and that would effectively remove, as we understand it, the requirement for hirers to offer guaranteed hours. What we don't know is what the appetite of our employment associations are to create that sort of collective labour agreement, because it's an unusual move for us, not something our in-country employment associations are used to, and it's certainly not something that the recruitment industry in the UK is used to, but it is an option. It is something we're exploring, and I believe a number of recruitment businesses are considering whether that might provide some protection for the end hirers.
It's tricky, isn't it? Because it's so beneficial for many workers to be undertaking flexible working. They choose to work in that way, and of course they have the right to refuse a guaranteed hours contract if it is offered by the employer. But for employers, they're understandably really concerned with the additional tasks they're going to have to carry out to offer these contracts time and time again over every reference period. So having some kind of agreement where Those who are in favour of working flexibly and don't want guaranteed hours are able to say, we opt out of this, a bit like the working time regs and the opt out of the 48 hours. That for me is the ideal. But I can see where the government was coming from this in wanting to avoid exploitation. It's just that there's a huge section with contingent workforces where it's absolutely critical to the running of the business. And Scott, sorry, you've asked about limited contracts and going into a bit more detail about that. You know, it's difficult in a webinar like this because, as Alison said, we're waiting for so much detail, but the bill refers to a limited term contract. We would know that as a fixed term contract. And it can be offered where it's reasonable. And again, what does reasonable mean? You can see this playing out in the employment tribunals, can't you, about whether it's reasonable to offer it or not. But where there is a limiting event, basically, so we're talking about a specific task which the contract is being entered into, so a particular project you're entering into, or where there is a particular surge in work, for example. And I'm thinking there about, when I think about this from a healthcare perspective and thinking with winter pressures, is there a way that we can justify offering limited term contracts to cover winter pressures? I can't offer you loads of details simply because the ERB doesn't contain that detail, but it's definitely something to watch out for.
Just on the last point that you raised there, Scott, as I see, no, I think this legislation is looking at workers and employees rather than the independent contractors that typically you would see as, say, a professional service company. That would be a separate point. That's not necessarily envisaged under this. Again, though, the limited contracts is again very similar to what we see in a number of European countries, where agency workers in particular can only be brought in certain circumstances, where there is that seasonality requirement, where there is a project piece of work. So again, it's shifting it back to that sort of European style of working and using contingent labour.
Okay, well, on the interest of time, I think we need to move on to the next section, so protection from dismissal.
Yeah, I think you can see how wide-ranging the questions are and the breadth and depth of the impact. We have got lots of questions, which we'll hold obviously to the end, as you say. Ben, it would be great to move on to the second section. So one of the other headline changes in the ERB is protection from dismissal. At the moment, employees gain unfair dismissal rights after 2 years, generally, of continuous service. Under the bill, that is set to change quite dramatically. Nikki, do you want to talk us through some of the implications of what the bill is proposing at this stage? This is obviously one of the most closely watched parts of the legislation.
Yeah, and it's another one that we won't see immediately. It will be pushed back. So again, don't panic, but there is definitely work to be done, I think, on this. So the government were proposing day one rights. So we don't have the 2-year qualifying period anymore. Of course, that's huge for employers in terms of resourcing and how you deal with new recruits. Most employers are used to having a bit of leeway when they make their mind up about an employee. Of course, employees and workers have discrimination and whistleblowing rights, but unfair dismissal rights kick in from 2 years. And they want to make it day one. There is a reference to an initial period where there will be a light touch on dismissal processes, and that was talked about being 6 to 9 months, so really like a statutory probationary period, but we don't have much more detail on this. We're talking about ping pong, and when it went to the House of Lords said, actually, what we want is a 6-month qualifying period in there. So bringing back a qualifying period, reducing it to 6 months, but still having one in there, because this is such a fundamental part of the government's manifesto when they came into power. I'll be hugely surprised if they agree to the 6-month qualifying period. So we're back to day one rights. I guess for me, this is looking at what you have at the moment in your contracts. Do you have probationary periods in there already? I expect you do, but if you don't, that's something to discuss and think about how you implement them, because they're going to be hugely beneficial to you if we have day one rights. I also wonder whether we will see a lot more fixed term contracts and use of agency staff, so that employers can test out whether an employee is the right fit for an organisation before it offers a contract of employment. I wonder whether that will happen, but you know, we're waiting for more detail. We don't know enough about this initial period at the moment, but for me, the focus is on that and using the probationary period or alternative methods to see whether the person is the right person for you in an organisation.
Yeah,
Thanks, Nikki. Sorry, go on, Ali.
Yeah, I was going to say, I think that's really important, that use of probation period. I also think some of the conversations we're having internally in our group is about what how this will impact potential claims, ACAS notifications, employment tribunal claims. We know that at the moment our employment tribunal system is under huge pressure, and rather than cases getting to an employment tribunal in 3, 6, 9 months, they're taking years to get to an employment tribunal. So one of the things we've been talking about quite a lot with our HR teams, but also our recruitment businesses, is about when you have an incident, and I think it's a habit we're getting into now, is really taking the detail down, making sure that you've got that information recorded, particularly in relation to witness evidence, because you could be taking witness evidence in line with the normal tribunal process, and by the time you get to a hearing, you know, memories have faded, recollections have changed, people interpret things differently. And so one of the things we're looking at already is training people, training our line managers, even training our recruiters to be taking that level of detail early on and recording it in their HR systems, so that you have that early protection, so that if witnesses move on, people change, you have an early record of the information. And I think that's going to be really important when we look at employment tribunal claims coming down the line.
Thanks, Alison. It sounds as though on both of those points, for guaranteed hours and potentially the day one rights, that organisations should at this stage start to think about how they prepare for the changes coming through. It sounds as though things like audit trails, reviewing policy, looking at probation periods, potentially reviewing the advantages of using recruitment businesses to actually put a level of protection in between the organisation and the individual worker are potentially solutions. Does that feel right, Nikki, from your perspective in terms of prep and timeframes? Some of our organisations that we work with are huge, and so implementing any change is always like trying to change the direction of a shipping tanker. So
yeah, and it's overwhelming, isn't it? Like the level of change that is being brought in for an employment law is overwhelming, to be honest. You look at it and go, this is going to take a lot of effort, and for employers it's huge as well. And I think getting started on seeing where you are now is key. So analysing for guaranteed hours workers, for example, what your contingent workforce looks like, how many have you got them on 0 hours or low hours, that's key, and that can be done now. If we take 16 hours as the low hours threshold, and we assume it is, for the contracts and the policies, probationary periods, for example, yeah, we can absolutely look at what you've got in place at the moment. Do we think it's going to comply with ERB? How much work is going to be needed? And that point that Alison made is absolutely key. If we've got day one rights, there will be so much more emphasis on HR departments keeping up and keeping on top of all the different issues, which we all know occur within workforces. It's about resourcing HR as well. So I think there's an awful lot that can be done now to make it less painful when the changes come in further down the line.
Yeah, and with some of these things, there's a risk that putting in a new infrastructure to try and avoid legislation can then subsequently be challenged. Presumably that's another reason for making sure that some of the groundwork is done as early as possible if organisations are looking at things like changing probation periods.
Yeah, I mean, the legislation, you normally get anti-avoidance measures that are included in new pieces of legislation. So, and a good example of that is the agency workers being included in the guaranteed hours. They saw a loophole and they went, okay, well, this is what we need to do to cover it. I do think it's worth, I'll come on to fire and rehire, which is a significant change, and where I think that changes can be made now in advance of that change taking place through the ERB. But you can definitely make changes at this point before the legislation comes in, and it's not going to be overturned. It's how we think about it once the legislation is moved in, and whether there are anti-avoidance measures included in that legislation that then becomes trickier. But the law is the law as it stands now. If you have got changes you want to make, they can be made.
Just very quickly on, some of those changes as well, just popping back very briefly to the guaranteed hours, I think we don't know what the reference period will be at the moment. We think it will be about 12 weeks. As a recruitment industry, we're very used to recording that, for monitoring that, because we have to in order to assist our clients with agency work and regulations. So as an industry, we're already prepared for monitoring that reference period, whether it be 12 weeks, 16 weeks, or longer. And so I would also suggest that you speak to your recruitment partners about how they monitor that period, what information they gather in that period, and how that can help you prepare.
Thanks, Alison. So shall we move on to statutory sick pay? So another key change within the bill. So the statutory sick pay entitlement potentially will move from day 4, as it stands at the moment, to day 1, and also potentially removes the lower earnings limit. That sounds relatively straightforward, Alison, but it potentially, in terms of cost and absence management, is quite a big shift for some employers, and potentially will impact a different cohort of workers as well. Could you just talk us through some of those changes?
Yes, I think this one is probably for me. So the big changes are that the 3-day waiting period will be gone. So it will be SSP from day 1. It is SSP as well. I think that's important to say. It's statutory sick pay. It's not, it's your company sick pay is still your own policy. And then the lower earnings threshold is going to be removed as well. I suppose one of the questions that I've been asked by a number of our clients is, where does that liability sit in a chain when you're using a recruitment business? And it's whoever is paying the wages, basically. So if you're using contingent labour that you're directly hiring, then that SSP is going to be your responsibility to monitor and manage. If you're using a recruiter, if you're using an employment business or provider of temporary labour, it's whoever's paying them that is paying the SSP. So for us as an employment business, we will be monitoring and managing that SSP as part of the service we deliver when we're providing contingent workers. One of the things I think you might see from our industry, it will be asking you to, and it probably feeds back into the guaranteed hours point again, I think you will start seeing recruitment businesses asking you to push for an end point on their contracts. So rather than open-ended contingent labour contracts, I think you'll see recruitment businesses trying to mitigate their own liability under this, saying, you know, is this a 6-month contract, a 12-month contract? I think you'll see a bit more push for those sort of fixed-term periods.
Thanks, Alison. And in terms of preparation for trying to understand cost and risk, what can organisations do at this stage to really think about how many people would be impacted that they're not already somewhere in charge rates or in finances picking up the cost of SSP?
I think it's that preparation and looking at your contingent workforce again and trying to really analyse the level of sickness. I mean, we, you know, as a business, we have thousands of workers out in the UK, and we have a very low level of SSP payout against those workers. It's not a common thing for us. We don't see lots of our temporary workers taking SSP. I think there is a lot of concern about it. So I think the first part for us and for any employer, I think, is to really look at the levels of sickness that you have and try and work back the additional costs that will arise from those 3 days, but not just the 3 days. It's really important to also remember that the lower levels threshold, earnings threshold, has also been removed. But I think it's going back for a period of time now and looking at that sort of pattern and seeing how it might impact, projecting how it might impact in, say, 12 months' time.
Thank you. And presumably using some of the agencies or managed service providers as a bit of a sounding board to try and get that data, and thinking about sensible agreements between different parties so that you don't end up in a dispute further down the line once those changes come in, and that all parties are really clear on whether there will be a cost burden and an admin burden and where that sits.
Yeah, absolutely. Yeah, I think all of those are important things to do. But that analysis, if you already had a managed service provider, they will already be capturing a lot of that information for you. So yes, relying on your partners, your recruitment partners, your MSP, your neutral vendor, to help you gather that evidence together, because you might not see when a temporary worker through an agency has taken SSP, because it's just been, you know, they're not there, they're not on site. But really getting that information from your partners and being able to help model, I think.
Thank you.
Okay.
So before we move on, shall we move on to the second poll, Terence? I think one of the big themes running through all of these reforms is visibility. So, you know, to be able to comply with some of these new rights in whatever way, shape and form they end up coming through, whether it's guaranteed hours or it's dismissal protection, the SSP point, it looks like organisations are going to need to know exactly who is in their workforce, how long they've been engaged, what the pay rates are, what the charge rates are, and under what terms they're engaged. It'd be great to just get a sense from people on how robust they think the visibility of their contingent workforce is at the moment. Again, if you click into the polls, you should be able to see how people are voting, different organisations.
That's right. So at the top, we've got 38% for both mostly digitised, can't say that word, and partially digitised, and then manual process with minimal visibility. Some businesses not having any visibility at all. So it's really a real mix there, mainly partially or mostly digitised.
Yeah, really interesting to see, isn't it? And I think certainly some of our existing clients on this call, and we spend a lot of time looking at data, but equally we've had lots of conversations with organisations recently who are just starting to say, how are we ever going to comply unless we have a digitalised process and some way of exporting data at the back end of it to be able to really get visibility and comprehensive reporting to stay compliant. Okay, thanks, Ben. Should we move on to fire and rehire? I always mix those up as well. So, and obviously another major reform is around the fire and rehire practices. These have been really heavily criticised. There's been some quite large cases publicised in the media around organisations using these inappropriately and the bill ostensibly is going to try and set new restrictions to drive through change. Nikki, do you want to share some of the background around the proposals to introduce the controls around this?
It's a really controversial topic, fire and rehire. It's actually incredibly helpful one for employers when they're trying to enforce contractual variation. But you'll remember the P&O case and the government weren't very happy about that. And this is a key part of the ERB for them, which is essentially banning fire and rehire by making it automatically unfair if you dismiss someone for this reason. There are a number of elements to it. And there are some exceptions to the automatic unfair dismissal rule. But essentially, you're going to have to be very, very careful with this. And for private organisations, you need to be in significant financial difficulties if you're going to rely on fire and rehire in any way. But there are also some kind of amendments which have been made to the legislation as it's moved through the various stages, which are significant for you. Fire and rehire, as I say, is actually incredibly helpful for an employer which is looking to make changes to contracts of employment. You'll know that you can't make a change unless it is agreed either by an individual or collectively if you're dealing with the collective agreement by unions. If someone doesn't agree the change and you try and force it through, they could claim breach of contract. And so what happens in many circumstances where there is a very good business reason for introducing the change is that you will have a period of consultation. You will hopefully get a number of employees to sign up to the change. For those that don't, you eventually terminate employment for some other substantial reason, if we're thinking about unfair dismissal, and you offer them immediate re-engagement on the new terms. That's fire and rehire. And that's what the government wants to limit significantly. I normally get involved in fire and rehire on a collective consultation basis, and it's really important to note that the collective consultation provisions of TORCA are going to be enhanced through the ERB. You will hopefully know that if you get it wrong and you don't comply with the collective consultation regs, there can be a protective award of up to 90 days pay. It's actually set at 90 days and it can be reduced. It's punitive, and that's gross pay. The government want to increase that to 180 days, so it's significant. So collective consultation comes into this when you're dealing with individuals and changes of 20 or more employees and 100 or more. The timeframes differ, but we're not just talking about redundancy as you would understand it. We're talking potentially about changes to terms and conditions. That's when the collective consultation provisions kick in. It's not purely about redundancy, so it applies to fire and rehire. There are some very limited circumstances in which you can push through fire and rehire. You can make changes to duties potentially. It all has to be fair. It's not just that you can push it through. There has to still be a fair process. What you can't do, there are some restricted changes which you can't push through fire and rehire without it being automatically unfair. And that includes pay, hours, pensions, etc. And for me, some of the most significant changes I see being made are to pay and to hours. So the fact that that's restricted is really, really significant for employers. If you are looking to make changes to rosters, the way in which people work, 24-hour working maybe, changes to pay, you are going to have to do that before these provisions come in, and they're due to come in by October 2026. So that's a year before the other bits I've been talking about, so guaranteed hours and non-fair dismissal. So that is something to focus on now, I would say. If you're looking to make changes to contracts, you have the ability to do it now. Fire and rehire still sits there. You have to be very careful about it, and you'll hopefully know that there's a code of practice. And if you get it wrong, there can be an increased compensation. So you have to be very careful with it, but it's still there as an option, and it is going to be severely limited when the changes in the ERB come through. So that's definitely something to keep an eye on now.
Yeah, so the key message there is probably prioritise this element of the ERB preparation and think about how you get your ducks in a row before we get anywhere near next October, and that timeframe will come around really quickly. Really interesting though, Nikki, just to hear a little bit about the enforceability and penalties that will be associated with this part of the bill. Can you give us a sense of enforceability and penalties for the other parts of the bill that we've talked about? Do we think that it's going to be easy to track, that there'll be some almost showcases early on after the implementation of the bill, and what those penalties might be around other areas?
Well, we're kind of waiting. It's so frustrating, and I know it's frustrating for people listening. It's frustrating for me saying it as well, to be honest. So, for example, the penalties for cancelling a shift for guaranteed hours, for a low hours worker, guaranteed hours under that section, we don't know what the penalty is going to be yet. There actually will be those showcase claims coming through. But as Alison said, the Employment Tribunal is absolutely inundated with claims at the moment. I'm sure the attendees are seeing a surge in grievances, therefore Employment Tribunal claims. That's not stopping anytime soon, and it will just increase. So these cases, when they get to the ET, will be pushed back and pushed back. So it will be a few years before we have those showcases, essentially. But that doesn't mean we won't hear the noise around it and people complaining and trying to interpret. And whenever you get a new piece of legislation, it's impossible for the government to anticipate every single situation that arises. So it's always about interpretation. What was the intention of Parliament when it put this piece of legislation in? And there will be lots of wranglings between employers and between employees and workers about what this all means. So, I mean, the changes come in, we will all be kind of debating it for a while, and then we'll see it play out in the ET when they finally get to the hearings.
I think we should all be ready that we're likely to see a distinct uplift in ACAS claims following each stage of the rollout. I think that's almost certain that we will see that distinct increase. I think the closest I can compare it to in recent times is probably how we all had lots of subject access requests after GDPR was implemented. And I think we'll see a similar sort of uplift, and then hopefully it will start to balance out again. And particularly as I think employees beginning to go to ACAS will suddenly find that rather than a quick solution in an ET coming through, that they're working on cases for years and years. And I think that will then start to curtail cases actually and people bringing through. But I think we should all be prepared for each stage. You're going to see a distinct increase in ACAS claims because your employees will not understand the legislation immediately either. And so if they see what they consider to be an injustice or unfair, they're going to start raising it to ACAS to really try and understand their own rights as well, I think.
Yeah, and that it is really interesting, isn't it? I think that as anybody who's interested in tribunal cases and a diversity of them is definitely going to have an interesting couple of years. Alison, I'm really conscious of time, so we're going to hop into the umbrella company regulation. We had a couple of people ask us specifically to cover this on the webinar. I think what we're going to do is do a specific webinar in the series around the regulation of umbrella companies and the changes coming through next year. But could you just touch on that for us in terms of the changes that we're going to see next year?
Yeah, absolutely. So the government and previous governments have been very concerned about umbrella companies for a long time now, and there's been numerous consultations over the last 4 or 5 years about how to regulate that part of the industry. And just for those who don't use that term, so I know we've got lots of HR people, when we're talking about an umbrella company, the other term is employer of record. And so some of the questions we've had coming through from our clients is about their risk. So I just wanted to very briefly touch on what we do know. So first of all, we know the changes are coming in April 2026. We are waiting for the results of the technical consultation. So a bit like all the other topics, there is still a little bit of uncertainty. But what we do know is that if an umbrella company doesn't pay the tax and social security contributions, there is joint and several liability. And that joint and several liability sits in different places. So if we look at what I call the standard recruitment agency model, so you're a hirer, you use a recruitment business to find you temporary labour. In that circumstance, if the umbrella company doesn't pay, the liability will sit with your recruitment business. So the person that hired the worker, that sourced that worker for you. And that joint and several liability is what we call strict liability. So what we were hoping was that there would be a statutory defence, provided that we all did good due diligence on the umbrella companies and that we all carried out, checks, which we will still continue to do. But what the government has said is no, it's strict liability. And if the umbrella company doesn't pay, that liability now shifts to the employment business, the recruitment business. Then we go a step up. If you have a model, if you have a model like Retinue, where there's a managed service provider or neutral vendor, the interesting part, not so much for the managed service provider, neutral vendors of the world, but that liability now skips the recruitment business, and it's the managed service provider, the neutral vendor, that is jointly and severally liable. So they will pick up the liability. And that's because the government is looking at whoever has the closest relationship with the hirer. That's where the liability sits. And so the final point is, when may a hirer be liable under the legislation? Well, the good news is it's very limited. It's only in circumstances where you hold the contract with the umbrella company. Now, that's not so common in the UK, but typically for businesses moving into the UK for the first time, they may use an employer of record to hold that labour until they establish their own payroll, their own teams in the country. And that's really what the government has been looking at. So where the hirer holds that contract with the umbrella company, that's the circumstances where the liability will shift to the hirer.
Thanks, Alison. So on that note, it's a good time just to jump into the third poll, I think, just to get a sense of supply chain management and the visibility you've got of the kind of risks and processes and procedures within the lower parts and often hidden parts of your supply chain. Could you just pop that poll up, Terence, and we can complete that and get a sense of where people are? And as people do that, I think we'll just move on to our final section around sexual and third-party harassment. So just before we move into Q&A, Nikki's going to talk a little bit about the new provisions around this. Nikki, sexual safety in the workplace is obviously something that many employers are conscious of, particularly within some of the environments we work in. So frontline services includes healthcare as a big sector for us. And there's again been lots of recent media campaigns around this. What further changes does the ARB propose to make around sexual harassment?
Thanks, Rachel. I think this is probably the hottest topic for me at the moment in terms of requests for training and advice on how to deal with sexual safety in the workplace. And it follows actually, and I'm not sure how aware attendees are of something called the Sexual Safety Charter, which is introduced in the NHS. And I do advise the NHS a lot, but I think it's a really good set of principles for any employer to adhere to. So if you are working on this topic within your organisation, I do recommend looking at NHS England's website, because they've got a whole policy on it. They've got the principles set out on how to address sexual safety and improve sexual safety in the workplace. The ERB and the government want to improve the situation. Obviously they do, and they're trying to strengthen the provisions which have actually and are already in place, and which came in October, about employers taking reasonable steps to prevent sexual harassment of their staff, essentially. And the government want to change that to say all reasonable steps to prevent sexual harassment. It's interesting for me that they focus on sexual harassment, because I specialise in diversity generally and discrimination. And for me, it's all protected characteristics where we need to focus on harassment in the workplace and preventing it. But this particular piece of legislation, which came in October, focuses on sexual harassment. When we look at taking all reasonable steps, I just question what you're doing to date about that, because you'll be conscious probably of vicarious liability under the Equality Act and reasonable steps defence to try and protect yourself as an organisation from vicarious liability. And I think there's a real focus on that. What training are you putting in place? What policies do you have in place? What risk assessments do you do about sexual safety in the workplace? EHRC has a really good guide on this, and I recommend having a look at that. And with risk assessments, I don't think it's purely about your staff and your employees. It's also about the risk that others pose to your staff and your employees. So if we take a healthcare setting, for example, patients, families, contractors which attend, agency workers which attend, you need to be aware of all risks to your staff and risk assess that. And so I query at the moment what risk assessments you're doing and what more you could do, because that will stand you in very good stead when it comes to making sure that you have taken reasonable steps. Just to be clear on that particular point, it's not a separate standalone claim if you fail with this, but if someone brings a claim and you haven't taken reasonable steps, there can be an uplift to compensation of up to 25% if you haven't taken currently reasonable steps moving forward, all reasonable steps. The final point to note is that sexual harassment, claims of sexual harassment, the government want to introduce that as a particular protected disclosure under whistleblowing legislation. It's not at the moment, and hopefully attendees will know about all the additional protection that a whistleblower has. They are looking to extend it and make disclosures about sexual harassment protected disclosures, and that's really, really important. I would say that my general learnings are that lots of organisations are looking to take the information they've learned about sexual safety and apply it to other protected characteristics. There's so much that can be done. And one of the main topics that I deal with is race discrimination in the workplace. And there have been an awful lot of learnings from case law recently on that. So it's a really hot topic for me. I think it will continue to be. We're going to see gender pay gaps reporting extended to ethnicity as well as disability. So this is one of those areas which is a hot topic and rightly should be. And hopefully we'll see real progress being made with that.
Thanks, Nikki. So really conscious of time as ever. We've covered a huge amount of ground, and slightly overwhelmingly probably. It's only really skimming the surface of the expansiveness and the depth of the bill. And we've not really got into specific scenarios that I know lots of you have already asked questions on. Let's just have a couple of minutes of Q&A and see if we can cover at least one or two of those. And as I said earlier, we will pick those up with people who've asked questions specifically outside of this session. So you will get a response to those.
Okay, so we have one from Simon. So hi, Simon. So it's been made clear how long the opt-out period, has it been made clear how long the opt-out period will be? Will the worker need to opt out every reference period, aka every 12 weeks, or is it more long-standing? That's probably one for you, Nikki and Ali.
Oh, Nikki,
you're on.
Oh, I thought I'd unclick, sorry. There isn't an opt-out at the moment. There's a possibility of the collective agreement, but that's difficult where you don't recognise unions, subject to what Ali said about what the regulations are going to say. Simon, hi. I think this is getting at the kind of, are we going to have to offer it every 12 weeks? The answer to that at the moment is, for me, yes, because you don't have this opt-out ability. I would like there to be, like the working time regs. I think that's really, really sensible, where you are reliant on contingent workers who really like being contingent workers and like working flexibly, but that opt-out doesn't exist at the moment unless you're talking about a limited contract. And Scott, hopefully I answered that question earlier, but the truth of the matter is we're waiting for more detail. I'd love there to be an opt-out, but there isn't at the moment unless you've got a collective agreement.
Okay, lovely. And then probably got time for two more here. So we have a mix of contractors, agency workers and 0-hour staff. What are the top things that you would do to ensure compliance? So Rachel, that's probably one that would lead with you.
Yeah, so my start point for everything is data, as those of you who know me. I don't think that people can make decisions without comprehensive data sets. So for me, the start point is, where is your contingent workforce? What does it encompass? What type of contractors? How are they engaged? What's their length of service? What's the cost of those workers? And you can then start to build from there and start to really look at what policy and procedure changes need to be thought about. What's the cost implication going to be? What's the opportunity to use different engagement methods to manage and mitigate some of the risk and the administration around this? And certainly, what does the cost exposure look like, and what can we do to actually try and minimize that cost impact across the whole supply chain? So let's not kid ourselves. If there's going to be an increase in cost to the employment business, that is going to pass all the way through the supply chain up to the hirer at some point in time. Equally, if there is risk that can be mitigated instead of engaging workers directly from day one as a hirer, why wouldn't you look at alternative mechanisms? So I think that for me, it's about looking across the supply chain, using data to inform those decisions, and trying to pull into different work streams, impact on policy, on risk, on procedures, on data and on cost.
Can I just jump in a little bit on that? I think really good point there from Rachel around how you engage the workers as well, because I think we're, as an industry, we're looking at, do we start using independent contractors more in certain circumstances? Do people shift their view around that? Do you start, perhaps you don't use agency workers at the moment? Is there a shift towards using agency workers for that sort of point Nikki made earlier about testing workers out before you engage them on a temp to perm basis? So I think that's really important, is working out the makeup and how your contingent workforce, what they look like, and then start speaking with your specialist partners about what it might look like in the future.
Thanks, Alison. So that brings us to the end of today's session. Sorry, Ben, I think we probably haven't got time for that extra question. I think we've explored some of those really significant reforms, but just remember, as you start on this journey or you're partway through the journey, we are here to collectively support and guide you. So reach out to us afterwards and we can make sure that we're talking to you about the best way to start that journey over the next couple of years. Huge thank you to our speakers, Nikki and Alison, for taking the time to join us. As I said, the recording of the webinar today will be available afterwards, and we will be sharing a more detailed white paper that takes a deeper look at the bill as we understand more of what's coming. So if you've got questions, please do reach out. We are here to help, and we will hopefully see you on our next webinar in the series.